How will the Renters' Rights Bill change tenancies? Well, the Renters' Rights Act is going to be with us before we know it. And if you're a landlord or a letting agent wondering what to do to prepare for it and what it all means, well, you're in the right place. And this is the place where you can get straightforward, practical advice on how to prepare for the Renters' Rights Act without all the politics and without all the fuss. There's been so much in the media about the abolition of Section 21, but the Renters' Rights Bill is much more than that. It's going to completely overhaul the way that we landlords run our businesses. And we'll need to do things differently as early as the summer of 2025. And it's not a question of if it's going to come into effect, but when. I'm Suzanne Smith, a self-managing landlord who worked as a business lawyer for 25 years. And I've run the Independent Landlord.com website since 2022, giving free content to landlords and property businesses. And now I've set up this YouTube channel to provide free, high-quality content to help you make sure that your property business is going to be ready for the new regime. Please click on subscribe so you don't miss out on future content. I'm going to be doing a lot of it and it's all free. There are no catches. Right, let's get started. This is part one in a series of free training on the Renters' Rights Bill called The Renters' Rights Bill Explained, and it does what it says on the tin. And for those lawyers watching, I'm going to be covering chapter one of part one of the bill today, but don't worry to everybody else, I'm going to try and keep it light. So I'm recording this video in November 2024, and I'm basing it on the draft of the Renters' Rights Bill as passed by the House of Commons Committee. It may change from now, but it's unlikely to be changing significantly. So today I'm going to cover the new tenancy system and how it's changing and what it all means for landlords and renters alike. The new rules on rent, and there's a lot of new rules on rent. The new rights of tenants to request pets, and new offences and fines. So that's enough for today. And I'll be putting out a lot more content as well. But first things first, the name is different. If you remember before, it was a Renters' Reform Bill under the Conservative, which had the focus on reforms. But the focus is on rights, the renters' rights. And I'm going to be doing another video on what they all are as well, all in one place. And so the Renters' Rights Bill is Labour's version of the Conservatives' Renters' Reform Bill that was just dropped before the election. And as you can see in this clip ahead, Angela Rayner clearly thinks it's different, even if she does seem to be channeling the M&S advertising with this clip on why their bill is different.
This is fundamentally a different bill. This isn't just a renters' reform bill, it's a renters' rights bill.
So what's all the fuss about? What's actually going to be changing with the Renters' Rights Act? But first things first. When's it all going to come into effect? And here's a clip of Matthew Pennycook explaining what's going to happen.
To avoid confusion and to ensure that renters on existing tenancies do not have to wait even longer for the threat of arbitrary evictions to be lifted, we intend to apply the new system to all tenancies in a single stage. We will appoint the commencement date by regulations at an appropriate interval after royal assent, and our intention is to give the sector as much notice as possible.
The new bill is going to come into effect on the same day for both new and existing tenancies, some sort of big bang for landlords and renters. Matthew Pennycook has said it might be the summer of 2025, which seems to me to be a bit early. I think it's probably more likely to be October, but you might be watching this in October and I may be wrong, let's see. But this is what I think at the moment. There's a lot that needs to happen before it can come into effect. So this new tenancy system is going to completely change the way that our tenancies work. And maybe the new tenancy system might make your eyes glaze over. It certainly does for me, but it's actually really important. So I'm going to start at the beginning and explain what assured short hold tenancies are, ASTs, and what they're going to be turned into, which is assured tenancies, ATs, but I'll say the long version to make it a bit easier. The thing about ASTs is they don't offer any long-term security of tenure to renters because it's easy for landlords to evict tenants without giving a reason after the initial 6 months by serving a valid Section 21 notice. And there are various hoops that a landlord would have needed to have jumped through to be able to do that. But provided that they have, it is actually really easy to terminate a tenancy if you're a landlord. And so the Renters' Rights Bill is ending all assured short-hold tenancies and will turn them into assured tenancies. And it's going to happen whatever we do once the legislation comes into effect. So what are assured tenancies? Well, they'll become the default tenancy, and because there'll be no more ASTs. The new assured tenancy will be a periodic tenancy. In other words, an indefinite tenancy, which will last until the tenant either serves at least 2 months' notice to quit, which has to expire at the end of a rental period, so it might be a bit more than 2 months, or the landlord brings the tenancy to an end by obtaining an order for possession using one of the grounds under Section 8, or if a tenant just moves out when they get a Section 8 notice. And so how will this change the way that we do things now? Well, the first thing is there are no more fixed-term tenancies once the bill is in place. And if you have an existing fixed-term tenancy on the commencement date for the bill, it will become a periodic tenancy. So if you're entering into tenancies now, before the Act comes into force, and they're a fixed-term tenancy for 6 months, 12 months, 2 years, it doesn't matter. They're not going to be allowed to continue to the end of the tenancy, at least on the basis of the bill as it is now. And I don't want it to be a hostage to fortune. And on the commencement date, they will become periodic. And let's hear what Matthew Pennycook says about it.
I want to be clear, it is the government's firm view that there is no place for fixed terms in the future assured tenancy system.
So there'll be no fixed-term tenancies at all in the future, not even for students. There'll be no minimum period. There'll be no renewals. I mean, in fact, renewals are a bit of a fiction anyway. You don't need to renew a tenancy even now, because once the initial term expires, it just goes on to a periodic tenancy at the moment. And but anyway, everything's going to be periodic once the Renters' Rights Act comes into force. And as I said, tenants will be able to leave when they provide the 2 months' notice to quit. So the next big thing is the abolition of Section 21. And this is the thing that's probably had the most amount of coverage in the press and the media. So once the Act comes into force, landlords will no longer be able to use the Section 21 no-fault eviction notice, which, as I said, is relatively simple to serve because you don't have to give a reason. And landlords at the moment can give tenants 2 months' notice using a Section 21 notice, and they don't have to give a reason. It doesn't mean that they don't have a reason. And if the tenants don't move out at the end of this 2-month period, the landlords can't go in and change the locks or anything. They still have to go to court to obtain an order for possession. That might take a little while, and then have bailiffs to remove them. But most people, when they receive a Section 21 notice, they do move out without the landlord having to take them to court. So that's the way it is now. How is it going to be in the future with Section 8? Well, Section 8 is a different process. It's an evidence-based process. And landlords, once the Act comes into force, will only be able to end a tenancy themselves if they can prove that they have a good reason. And these are called the Section 8 grounds. And there's a big long list of Section 8 grounds. There are some new ones, and I'll be going through them in another video. And the notice periods will be longer too. And so the grounds are things like rent arrears, if the landlord sells up, or if the landlord wants to move in, and there are lots of restrictions over it, which, as I said, I'll do on another video. And as a little aside, once we move into the new regime, because you're going to have to provide evidence and it's going to be more complicated, it's really important to use specialist solicitors and not use eviction specialists who aren't regulated by the Solicitors Regulation Authority. And here's the link to check. Let's now move on to rent, because there's a lot in the bill about rent. The first topic we can deal with is rent controls. Now, there are not any rent controls in the Act. There was a lot of speculation over the summer that they might be brought in, but they haven't. And you can listen to Matthew Pennycook now, in his own words, about rent controls.
We remain opposed to the introduction of rent controls, which we believe could make life more difficult for private renters, both in terms of incentivising landlords to routinely increase rents up to a cap where they might otherwise not have done, and in terms of pushing many landlords out of the market, thereby making it even harder for renters to find a home they can afford.
So Labour have been very clear that they're not going to introduce rent controls. Now, there has been a term that's been used called rent suppression, which was coined by David Smith. He's a solicitor at JMW. And his view is that it's going to be more difficult for landlords to increase the rent when the Act comes into force. And so it will have an effect of suppressing rent. But it's not a rent freeze and it's not rent control. But let's start first with how landlords are going to be able to increase rent once the Act comes into force, because it's changing. So at the moment, landlords can change rents in lots of different ways. There might be a new fixed term agreement, and that's something very popular with letting agents because they charge for doing another fixed term. Although you don't actually need to enter into a new fixed term, you can change the rent according to a rent review clause in the contract. And you can do it by agreement, and that's very popular. You might do it by an addendum after chatting to your tenants. And you can also use a Section 13 notice, which is a statutory procedure. There's a notice on the government website, and you fill it in and you send it to the tenants at least a month in advance before the new rent date. So Section 13 is already in place. When the Renters' Rights Act comes into force, there will only be one way to increase rent, and that is using the Section 13 process. But they're making some modifications to it. Whereas at the moment, you only need to give 1 month's rent, or at least 1 month's rent, to end on the rent payment date. In the future, when the Renters' Rights Act comes into force, you'll need to give at least 2 months' notice using the Section 13 notice on the government website, and will only be able to change rent once a year. So what this all means is that you won't be able to use a rent review clause, and if you have one in your tenancy agreement, then it will be null and void. You also won't be able to agree it informally or sign an addendum unless you've already served a Section 13 notice and then you've negotiated a lower rent with the tenant afterwards. Is it difficult to do the Section 13 notice? Well, no, it's not. The form's already on the government website, and here's a link. And we can increase rent by Section 13 now. I've done it, but at the moment you can only do it if the tenancy is periodic and it doesn't have a rent review clause. So in the future, what I predict is that letting agents, instead of doing the annual fixed term renewal, they'll do an annual Section 13 notice and charge for it. It's actually not that difficult to do yourself if you've got the time and the inclination to do it, of course. So the next thing is greater rights for tenants to appeal rent increases. And let's hear what Matthew Pennycook says about this.
But we do want more tenants to take a challenge against unreasonable rent increases to the tribunal. The tribunal will have an important role in looking at what a reasonable market rent is in an area and assessing whether a particular rent increase is reasonable.
So tenants already have the right to appeal against a Section 13 notice if they believe it's above the market rent. And they do this by appealing it to a first-tier tribunal, and you might see it referred to as an FTT. But if they do that at the moment, it's very risky. And Matthew Pennycook has said it's vanishingly rare for tenants to do this. And the government want to change this. They want to make it easier for tenants and encourage tenants to challenge rent increases. Whereas now the tribunal can decide to increase the rent over and above what's in the Section 13 notice if they think that the market rent is higher than what's in the notice. In the future, they will only be able to keep the rent the same or reduce it. So that means that the tenant has no kind of downside for doing it because the rent will either be the same or go down. And there's another thing in the bill to encourage renters to challenge rent increases. And that's because by challenging the rent at a first-tier tribunal, they'll be able to delay when the new rent comes into effect. So even if the rent is entirely reasonable and below inflation and well below market rent, if the tenant actually appeals the rent increase at the first-tier tribunal, it could be a number of months until the rent increase comes into effect, which, I personally think is not fair, but that's the way that the rules are at the moment, because if there is a reasonable increase, I don't see why the landlord should have that rent increase delayed just because the courts take a long time to come to a decision. There's another thing as well. The tribunal can actually delay it even further if they believe that the rent increase will cause undue hardship to the tenant. So there will be no risk to the tenant in appealing a rent increase to the first-tier tribunal. It's likely that more tenants will do this. So what can landlords do? Well, when you're increasing the rent in the future, make sure you have evidence about the market rent. So you're not just going like that or putting it up by some arbitrary amount. And it's a good idea when you send the Section 13 notice to send a letter as well and to speak to them about it, which is just polite, I think, rather than getting a notice out of the blue. So when you send the covering letter, you can say that you're keeping the rent below the market rent and say what you think the market rent is, and it's normally a range. And then if you're reasonable and you're not putting it up by a lot in one go, then it's probably less likely that tenants will appeal. Where tenants tend to appeal is where they feel that something is unfair, which means a big increase. Even if it is still to below market rent, if it's a lot more than inflation, then the tenants can feel quite aggrieved. And it's difficult for tenants to try and find more money for 20-30% rent increase all in one go, even if the new rent is still going to be below market rent. And also, keep records of when you do decide what the market rent is. You might want to keep copies of adverts of similar properties. You might have seen something on Rightmove. You might have advice from letting agents, and this is something that letting agents can really help with going forward. So the next topic is what you need to do when you set the initial rent, when you're listing a property, and the banning of rental bidding. And this topic has had a lot of publicity, and I'll show you a bit here.
We remain committed to ending rental bidding wars, which all too often price out hard-working families from a home. Landlords and letting agents will be required to publish an asking rent for their property and will not be allowed to ask or encourage or accept a higher offer. Real change for working people.
So rental bidding is not something I've particularly come across. I think I've only had one applicant offer to pay more than what I was advertising the property to be. I didn't accept them because I didn't think that they were the right tenant. And I set the rent of what I think is a fair market rent, and I don't go above it. And that, in effect, is what's going to happen in the future. When you list a property, you'll have to state what the rent is, the proposed rent. And if a tenant or applicant comes to you and says they're prepared to pay more, then you cannot accept it. What I suspect will happen is that landlords will advertise a property at a high market rent and then receive rent offers from tenants that are below it. So there'll be kind of a reverse bidding. Although having said that, the market has softened since the post-pandemic period. And I recently let a property and I didn't have any rental bidding at all. And I just concentrated on trying to find the right tenant and not worrying about trying to get another 25, 50 quid out of tenants, because it's going to be a long-term relationship with tenants, and tenant selection is going to be even more important than it is now. And that's a topic for another training session in itself. So another big question is, will paying rent in advance be banned? And the truth is, at the moment, as it stands, it is not clear. You have some lawyers saying it is banned and other lawyers saying it's not banned. I personally think it's quite a tortuous reading of the bill for it to be considered as banned. It doesn't say it in words of one syllable. And it was raised in committee and the government are looking at it. Here's what Matthew Pennycook said in committee about it.
Very clear that the practice of landlords demanding large amounts of rent in advance must be prohibited. Now, while it might be argued that the interaction of the new rent periods provided for by Clause 1, i.e. a month or 28 days, and the existing provisions of the Tenant Fees Act 2019 relating to prohibited payments provide a measure of protection against requests for large amounts of advance rent, I'm increasingly of the view, speaking candidly, that there is a strong case for putting this matter beyond doubt, and I'm giving very careful consideration as to how best that might be achieved.
The next topic is the right for tenants to request pets. Now, I know that a lot of landlords don't like renting a property to tenants with pets. I used to be like that, but I changed my mind when my adult daughters explained to me, actually, it's really important for people to be able to have pets. It's good for their mental health. And also, I think that people with pets do tend to stay longer. I am now a pet-friendly landlord, and I haven't had any significant damage at all from pets. In fact, there's far more wear and tear from humans. And what's going to be in the Act is an implied term of every assured tenancy. So if it's not in your agreement, it's still valid because it's implied by the law into it. So there's an implied right for a tenant to keep a pet if the tenant follows the process in the bill. And the process is quite straightforward. They have to ask in writing and they have to describe the pet that they're wanting consent to keep. And so when the landlord receives this written request, the landlord has to make a decision and get back to them within 28 days. And this period is a bit shorter than it was in the original Renters Reform Bill. And the landlord cannot refuse to give consent unless they have a good reason. And one of those good reasons is set out in the bill, and that's if the lease agreement prohibits it, if a landlord has a flat. And sometimes in those lease agreements with the freeholder, the landlord isn't able to have somebody in the flat with a pet, or there might be a consent procedure where the leaseholder, the landlord, will have to contact the freeholder to ask for permission. And if the freeholder says no, then the landlord will have to accept that, and the tenant won't be able to move in a pet. So the landlord has to reply within 28 days, and the government is intending to set out guidance which will explain and give examples of good reasons. So I think we'll have to use our common sense. It will be things like, the pet is unsuitable for the property. You have a huge Great Dane in a studio flat. Another one is too many pets for the property. And of course, that will depend on the size of the property. Another obvious one, I think, is for HMOs. Unless they're on a joint tenancy, in which case they're people together as kind of a unit, even if they're technically different households. But if you've got a property that's let by the room, I think it's entirely reasonable to turn down a request for pets. You'll never know if somebody's going to be moving in with an allergy, and some people just might not like pets. And I think it would be a good reason to refuse it if it's an HMO. And another one would be if there's a dog and the tenant is out all day, and because although you can get dog walkers to come, dogs don't like being left for a long period of time and bark and cause a problem for the neighbours. And I've certainly seen that there in some of the streets around. There are lots of yappy dogs that are being left alone, and that's not good from a welfare point of view. So I think that possibly that would be a good reason to turn a request down. And also allergies would be another good reason. So something to help landlords, because pets can do damage, is that landlords will be able to ask the tenant to take out pet insurance to cover damage for the property, or charge them for pet insurance that the landlord will take out themselves. And this will be a new exception under the Tenant Fees Act. We're not quite sure how this will work because it is a bit complicated, but watch this space. So just a couple of tips before we move on to the next point. It's really important to have a pet policy, and it sets out your expectations for people when they have pets. For instance, don't go on holiday and leave your dog alone and have somebody in to feed it twice a day. That is not acceptable. And there are other things as well. By having a pet policy, you can reduce the risk of pet damage. And I have one, and I'll share a link to it in the show notes. Another thing is to give consent in an addendum, so it's a formal amendment to the agreement. And I think it's a good idea to name the pet, and describe the pet. So it might be a dog called Millie, who's a black Labrador, and you would put on the addendum Millie, a black Labrador, because that way there's no confusion over which animal you're giving consent to, because you're not giving consent to for the tenant to have all animals, but just to have that particular pet. And so I did this recently when my tenants had already had a dog and a hamster, and they wanted to get a kitten, and I added Dora to the tenancy agreement by an addendum. And, they liked it. They liked the fact that Dora is officially accepted as a pet, kind of like a four-legged permitted occupier. Then the next topic is just a small one. It's liability for council tax. So at the moment, there's a quite confusing area of law about what happens if a tenant is in a periodic tenancy and they move out before the end of the notice period. And the answer depends on whether it's a contractual or a statutory periodic tenancy, which is a complicated thing in itself. But the new law is going to do away with that, and it's going to make it clear that the tenants have to pay council tax until their notice expires rather than the day they move out. So that is good news for landlords, and there'll be no confusion in the future. And then the final topic is new offences and fines. And I'm also going to touch on rent repayment orders. They're not technically in that bit of the Act, but they come under this category. So the short version is that the Renters' Rights Act is going to toughen up the penalties considerably. And this is just a quick overview. The maximum fine is increasing to £40,000, and there are going to be new offences, for instance, knowingly or recklessly misusing a ground for possession. And rent repayment orders are doubling under the bill. Tenants have a right to apply for a rent repayment order if their landlord is guilty of certain offences. And here are the existing offences. It's already there at the moment. And in the Renters' Rights Act, there will be new offences. And these are the new offences that will be added into the Act. Superior landlords will also be liable for rent repayment orders if the intermediate landlord breaches the offences. And so this might happen in a rent-to-rent situation where you have an owner of a property who enters into a lease with an intermediate landlord, a rent-to-renter, and then the rent-to-renter, say, has an unlicensed HMO. There was a court case in the Supreme Court. It was decided that only that intermediate landlord's responsible, and the bill is unpicking that and making the top landlord, the superior landlord, responsible as well. On top of that, rent repayment orders are going to be doubled to 2 years rent as a maximum, and companies, directors can also be liable as well. So this is going to make rent to rent a lot more risky. So, and that brings me to the end of this video. I hope you found it useful. The next video in the Renters' Rights Bill Explained series will be on what we need to do differently. So if you found this video useful, please subscribe so that way you won't miss out on future content. Let me know what you think about it by leaving a comment. I love to read the comments from people. See you soon.